If you want to join me in the conversation, I want to welcome back attorney Peyton Inge to the program. He's been on the show with us before, and I wanted to get his take on what's going on the legal front when it comes to trucking news. He is a trucking attorney, and he helps defend trucking companies in court when these companies are being sued, litigation is being examined, that kind of a thing. And Peyton, I want to welcome you back, man. How you been?
Pretty good. How about yourself?
Oh, doing well, doing well. Thanks for coming on and spending a few minutes with the drivers out there. We're going to cover a lot of ground with this. We're going to talk about the Susan Collins Amendment. What is that going to mean? A couple of other things that are on the docket. But I wanted to start off and get your thoughts concerning what's going on with FedEx in the latest decision on worker status. A federal appeals court in California ruling that 2,300 workers at FedEx Corporation's ground unit are classified as employees and not contractors to the package delivery company. Now, a lot of folks may be hearing this, and I know a number of states are engaged in legal battles determining, whether truck drivers are employees or independent contractors. I know you've had a chance to read through this. What are some of your initial observations with this?
Well, the initial observation is just that, this is a California venue, and that you can count on those courts to take a little bit more of a liberal approach to classifying independent contractors as employees than you would find in most of the rest of the country. The courts out there tend to be a little bit more eager to extend the power of the state and to determine that an individual performing a job is not doing so for himself. He's actually doing it on behalf of a company. And so while this was not a particular surprise, the implications that it has are broad, and trucking companies anywhere in this country should be very, very aware of that decision and of the potential implications.
And from this standpoint, a number of other states are also looking at trying to change employment classification. I know that Washington State has had this on the front burner for quite some time. In your humble opinion, do you think that FedEx has a chance to maybe appeal this? Do you think this is going to work its way back through the court system?
Well, I think they're going to have to appeal it. A decision of this magnitude could cost them an immense amount of money, both in terms of California taxes and then in terms of federal taxes. And it has significant implications for FedEx in terms of the Fair Labor Standards Act for the unpaid minimum wage, and then the overtime computation. So this type of a ruling will have to be appealed, and my guess is that FedEx is probably already working on that.
As we speak, yeah, probably no doubt about that. When you say overtime, I think it's a very interesting point here, because can people or maybe a class action lawsuits be launched that could file documents to try to maybe collect, say, overtime from prior periods? Would that be something that could come up? Have you seen something like this before, where folks try to collect on money that they think might be due them from years gone by?
I've never seen it in the trucking context, but you've heard rumors of it. But there's certainly an abundance of law out there that allows an individual to come forward and claim unpaid overtime or minimum wage for prior pay periods. I think what we're going to find in most cases is that the folks that were previously classified as independent contractors are paid well in excess of minimum wage. The only real issue you would have is, was it computed properly? And I think that's where you'll have some issue with looking at how it should have been, computed according to the Department of Labor, because they weren't paid based on an hourly computation. They were paid as if they were, in fact, independent contractors. So you're going to have some problem trying to justify those two pay styles.
And it's interesting here because California, a lot of people have said, is all about the revenue. You can look at the CARB requirements, California Air Resources Board emission requirements, as one item that points to the dollars out there. Is it a question, do you think, of just simply trying to raise more revenue for the state of California? Is that something that should be looked at as part of the equation?
Yes, sir. In California, that's probably 95% of what you're dealing with is the effort to raise revenue. I mean, the state's been running in the red now for, a decade, something along those lines. They can't pay the teachers. They can't pay some of the other government employees. So they're doing everything they can to try and raise that revenue. And they've picked the trucking industry in this case because of some of the types of paperwork and types of control that a company has to provide and then exercise over a driver. I mean, California's attempting to make the claim that that control and that paperwork entitles the state of California to classify those individual truck drivers as employees of FedEx and then collect taxes from FedEx as a result.
Do you think this could be, or is this a direct threat to the independent owner-operator business model that's out there today? Are more and more states going to be looking at this?
More and more states are going to be looking at it. I think there will always be a market for the independent owner-operator. The folks that should be concerned, however, are the folks that pull exclusively for one company. Maybe they're leased on to just that company. They're not pulling loads for anybody else. They're not pulling loads on the side. Or maybe the contract prohibits them from doing that. Those are the folks that ought to be careful, and those are the companies. Typically, they're going to be smaller companies that should have a very wary eye on the horizon when they're looking at changes and decisions like this.
From a defense standpoint, one of the statements I was reading from FedEx Ground Senior Vice President Carrie Blanchett said in a statement, "We fundamentally disagree with these rulings, which run counter to more than 100 state and federal findings, including the U.S. Court of Appeals for the D.C. Circuit upholding our contractual relationships with thousands of independent businesses." So is the groundwork there based on that statement, more than 100 state and federal findings that go counter to this? Does FedEx have basis for an appeal based on historical precedents that are in place with this case?
Well, they absolutely do. I haven't had the opportunity to read all of the pleadings, but what we typically find in trucking cases, and I'm not limiting this to just specifically the employee, independent contractor question, but in trucking cases, you're dealing with a judge and a jury that in most cases does not understand the intricate nature of the trucking industry, be it bills of lading, be it leased onto. They just don't understand that concept. And so where you have federal regulations that specifically say this does not create an employee relationship, the local courts are sometimes willing to simply overlook that, either because they don't understand it or because it hasn't been properly argued to them. And I think that's what we're probably looking at out in California is that the state brought the claim in an effort to raise its revenues. The California court was more than eager to exert its authority and to identify these folks as as employees because it fits within their little understanding of what an employee is supposed to be, and they don't understand that a bill of lading is not an exercise of control over the carrier or over the individual. It's simply the company telling the driver what it's carrying, when it's going to be there, and that that bill of lading, establishes the rights and responsibilities of a number of different folks, not just the company and the employee or the independent contractor.
FedEx, their statement is very detailed. They also went on to say that it's enhanced operating agreements with the independent contractors will change its independent service provider agreements in the states of California, Oregon, Washington, and Nevada. The court ruling said the panel held the plaintiff FedEx drivers or employees as a matter of law under California's right to control test. Now, I've never heard that before, and obviously I'm not playing an attorney on radio, and so I'm turning that over to you. What does that mean, California's right to control? I mean, it sounds kind of obvious on the surface that they want to try to control the commerce out there, but is it more than that? Am I on the mark, or am I missing that?
You're definitely on the mark. Essentially, the right to control, it has a number of different elements, but it creates a presumption that an individual is an employee in certain instances, and those examples or instances are generally available and easy to apply with respect to, say, your the guy that shows up at your office to wash the windows, or that you might outsource your accounting to. Those types of tests are designed and easily used in those types of employment situations. The right to control test is not so easy when you look at the trucking industry, particularly because of the bills of lading. If you're telling people what time to show up to pick up a load, how many hours they can work, you're requiring them to attend safety training, things like that. It's much more of a gray area if you look at it in the context of a developing trend of law that attempts to classify as many people as possible as employees for tax purposes. And obviously a lot of these courts simply are not familiar with the some of the federal regulations that would say, look, this is an independent contractor, slam dunk deal. There's simply no question there. And even the Department of Labor sometimes forgets what those regulations actually say. So that is your right to control test in a nutshell.
What will this do to, say, independent contractors signed on with FedEx that are outside of the state of California, that they may not run intra-state but run interstate? Does that also change their dynamics? I mean, is that a whole other bailiwick here?
Well, from the company's perspective, it's going to change the relationship if you have a driver that lives in the state of California or that moves to the state of California. From the owner-operator's perspective right now, if he's operating outside of the state of California, there is no real impact on him. However, it's going to be difficult to predict how a decision like this will affect the company's decision moving down the road. So it's kind of hard to say. I would say that at this point there is no direct impact until the company begins to change its internal policies and procedures, and other similarly situated companies begin to examine their potential risk and make decisions based on that.
I would also, too, and again I'm going off into the weeds here, that labor unions or labor contracts would also come into play. Is that a factor at all in this with the independent contractor model?
It probably is not much of a factor in California in this particular decision, but if you were looking at other states where you have a history of that type of behavior or unified collective bargaining, it would probably be much more of a factor. You might look at California or Jersey as a prime example of that, and Michigan too for some cases.
All right, drivers, I got a break here for just a couple of minutes. Attorney Peyton Inge with me. It's 8888 Road Dog. Drivers, are you concerned about this, the fact that more and more courts are now ruling in favor of states? In other words, they are saying that if you're an independent contractor, you could be classified as an employee. What would that do to you out there? Have you ever faced anything like that where your employment status is being challenged out there? What are your thoughts on that? Are more companies starting to talk about that? Interesting case about what went on with the FedEx Corporation. If you got a question for Attorney Peyton Inge, the phone number to dial in, it's 8888 Road Dog. Some more ahead for you as we continue on with Sirius XM's Road Dog Trucking News coming up in a few minutes. Stay with us.
The news and issues affecting drivers. Now, back to Sirius XM Road Dog Trucking News.
Drivers, the one thing about the trucking industry, you can always bank on that it's going to be very complex and also very challenging legally. There's a lot of things that are thrown your way, drivers, from the hours of service, 34-hour restart, that, and it's really getting into, classifying employees. Are you an employee? Are you an independent contractor? It's very tough to navigate through that, trying to figure it all out. That's why I've got Attorney Peyton Inge with me. It's 8888 Road Dog. And Peyton, sir, thank you. A lot of folks are calling in with some questions and comments. Let's go to Corey in Texas. Thanks for waiting here on with Attorney Peyton Inge.
Good afternoon, gentlemen.
Hi, sir.
I'm an owner-operator, and I'm leased on with a carrier hauling frac sand here in Texas.
Okay.
And my take on it is I own my own truck, and I'm being dispatched by my carrier running their paperwork under their DOT number, and I truly believe I'm an independent contractor, because I can tell them that I want to go home at any time or refuse loads at any time, so it's kind of up to me when I want to run. And my take on FedEx is, did the guys own their own trucks, or did they have to, or were they forced to lease the trucks from FedEx?
Okay. Peyton, what do you think? I mean, he's operating under their DOT number, but he says he's got the ability to be able to go home whenever he wants to. Is he an employee or an independent contractor if he's running under their number?
Well, he's going to be an independent contractor, and in Texas, nobody's ever going to argue that.
It's a right-to-work state, right?
Yeah, it's a right-to-work state, and that's the way we've been doing business, since we could do business. It works as hard as you want to, as long as you want to, and somebody's going to pay you to do it. You go out west, and it's a little bit different. And in FedEx's case, I believe that most of those drivers were leasing trucks. I think there were a few exceptions, if I remember correctly, but most of those drivers were leasing trucks.
Right.
But the right to control out there is what they focused on. So you're looking at elements, again, like the bill of lading, where you're controlling the load that's carried in most cases. You're controlling the hours of service. You're controlling the training that these individuals have to go through, and things of that nature. Under California law, the state presented enough evidence that the court found that was evidence of control sufficient to identify these folks as employees as opposed to independent contractors.
It sounds like, Corey, from your standpoint, I mean, you're doing everything correctly out there. Are you hearing from other drivers that are concerned about this as well? Have you heard from folks running into California that this may be a worry?
I haven't particularly talked to anyone running into California about this, but
okay.
I mean, if this thing does grow, I mean, could it jeopardize my situation running and doing what I'm doing?
Yeah, that's what I was wondering about earlier. I mean, could this change the independent contractor model as we know it today, Peyton?
Well, it would have to change at the federal level for it to affect intrastate carriers, particularly in Texas, things like in states like that. Until it changes at the federal level, I don't think you're going to see any change in the model. However, when you start talking about interstate carriers traveling into California, or they have drivers in California, then it could begin to affect, certainly those companies relatively quickly in terms of how they have to kind of step back from exerting control over the individual driver in terms of how that load is delivered, when it's going to be dropped off, that kind of thing, which, as we all know, is a crucial and critical part of the trucking business. It has been for years.
I would have to think that if there's dollars that are involved here, that this is going to become more prominent as we go forward, that these considerations are going to be coming up either in the boardroom or through the legal system. Are we just beginning to see the tip of the iceberg with this in your estimation?
I think so, yes.
Okay, let's go to Freight Shaker. Next up in Indiana. Thank you, sir. What's your question for Attorney Peyton Inge?
Yeah, I'm in a similar situation. I'm an owner-operator, but like the FedEx and contractors, I own my truck. It's got the company logo on the fairings back there. I haul their trailers. I'm not permitted to haul anything else. Mm-hmm. I use their bill of lading. I get paid through them. I get 1099. I have to wear a company uniform. Mm-hmm. I now have e-logs on my truck, which was provided through them. Mm-hmm. And I don't see, except that I don't operate in California, I don't see how it would not be a same situation. I mean, they direct me all the way.
Yeah. I mean, everything that you're describing here, you would think that you are an employee. What would you say to that, Peyton? What's your response?
Well, at the state, it would depend on what the rules were out there in Indiana, and I have to admit off the top of my head, I'm not exactly up to speed on Indiana rules. But from the federal level, I'd say you're still safe in terms of being qualified as an independent contractor. Under the California model, you would not be. Certainly under the New York model either.
California has the ability to just arbitrarily assess a fee per gallon. Congress can't come across.
Right. Yeah, that's absolutely. No, that's something that's going into play come January. There's some talk that the price of fuel in California is going to rise maybe 15 to 20 cents a gallon, part of the cap and trade program. But, man, thanks for the phone call. Mountain Goat. It's a great handle in California. Welcome, sir. You're on with Attorney Peyton Inge. Great handle.
Thanks for taking my call.
Yes, sir.
There's a big difference between the owner-operator that, if he wants to go southern routes this week, he has that choice. Or if he, doesn't want to go to California, he has that choice to take that load.
Okay.
It's a whole different model. I mean, you're comparing apples and oranges.
Okay.
A FedEx driver that comes to your door wearing the company uniform, they're getting rid of the deep pocket, and the lawyer knows what this is that they are making the independent contractors because health insurance, sick time, workman's comp, they're all putting it on the backs of the individual. And in fact, the FedEx delivery drivers have to they go into a contract. They're allowed, if they, I've talked to some, is to get a loan for their vehicle, they have to follow FedEx specs. They can't have their own truck. It has to meet the specifications. They are separating, all the little trucks running around are not FedEx owned, but they have the logo and they have to follow the specifications.
Right.
And it's basically, you're looking at the one model saying, well, California's after more taxes. I'm not going to really argue that, but I'm also looking at the company side is they're trying to, they only own their trailers.
Okay.
The power units, the local delivery units are all independently owned. They're trying to eliminate a deep pocket.
Right. Now, when you say deep pocket, you're talking about expense, trying to eliminate that expense?
Expense, liability.
Okay. Shifting it from the corporate books onto the independent contractor, in other words.
And they control whether or not they have loads. They, what the timing is.
Okay.
Yes, there's a lot of timing involved in the industry, but theirs is very specific, and they have more control of the individuals to an extent that none of your true owner-operators would accept.
Now, are folks worried about this? You said you've talked to a lot of folks that are involved. They are in this particular situation. Are they concerned? What are you hearing, in other words?
Well, they're caught in a catch-22 of, they're trying to make a living, but they're also being held to a different set of standards where, FedEx could say, we're not going to use you again.
Right.
And they've got the money invested in the truck that they can't use. I mean, it's completely the FedEx specs.
Yeah. Okay. Yeah. All right. I appreciate it, Mountain Grove. Thank you, man, for the call. And let me ask you this, Peyton. I mean, it sounds like this is a very complicated matter. There's a lot of twists and turns with this legally that still have to be sorted out. I know this is going to get appealed in some way, shape, or form out there, but when you look at cases like this, I mean, do you have to literally uncover every stone, look in every nook and cranny to try to figure out, what an employee designation might be, the rules of the road? I would imagine can get very much bogged down in the weeds, so to speak.
It can. The biggest issue you run into is a simple failure to properly articulate how the trucking industry fits into the elements of control that are just kind of established by elected representatives. Those are broad controls, and they're not tailored to the trucking industry. And if you can educate the judge or the jury, or however you're doing it, on what those particular elements are, in your case, you've got a lot better chance. Obviously, the FedEx model is common to many of the largest trucking companies in the country. So what they're doing now is something that has been done for decades, and it's not uncommon for a large trucking company to require drivers to attend safety training. And in fact, if they don't require those independent contractors to attend safety training, you've got some liability issues in certain states, things like that. So you're kind of caught between a rock and a hard place in terms of making sure your independent contractors are driving trucks that are up to standards in terms of safety and performance, and making sure that you're fulfilling all of your safety obligations. So it's definitely a carefully trod path.
Yeah, absolutely. Just stay tuned, so to speak. Absolutely. Peyton, hang on. Time for a news update. Drivers, you're more than welcome to jump in. It's 8888 Road Dog. Yeah, interesting story coming down from the Ninth Circuit Court of Appeals involving FedEx and the employment classification of independent contractors versus employees. I know a lot of you guys run under these models. If you want to weigh in on the story, I've got it up on my Facebook page, SiriusXM's Road Dog Trucking News. When we come back out of the break following news, I wanted to get Mr. Peyton Inge's thoughts concerning Representative Susan Collins and her amendment that would put a pause on several regulations related to the hours of service that a truck driver can log before taking that mandatory break. We're going to talk about Congress coming back into session, and you know that one of the first things they're going to look at is this amendment by Susan Collins. And we're going to talk about the legality of all of that when we come back next, right here on the SiriusXM Road Dog Trucking Channel.
The news and issues affecting drivers. Now, back to SiriusXM Road Dog Trucking News.
Time for a news update right here on SiriusXM's Road Dog Trucking News. I'm Mark Willis, and this portion of the news brought to you by Schneider. Call 1-800-44-PRIDE. Lots of things happening out there. Wisconsin Department of Transportation Chief Mark Gottlieb is going to ride with a truck driver to observe just how the state's regulations affect drivers. And Gottlieb will ride with over-the-road driver Lisa Burrow for about 50 miles. And he said, quote, I want to see how Wisconsin's regulations, the road repairs, even rest areas have affected drivers. And the event is being coordinated by the Women in Trucking Association, will also highlight the Wisconsin Department of Transportation's job resources area. And according to Mr. Gottlieb, jobs in the transportation industry today are plentiful, and it's important for me to see that the tools, the training, and the technology that we have in place through WisDOT are truly supporting this growing industry. U.S. NAFTA freight totaled $103 billion during the month of June of this year, as all 5 major transportation modes, air, vessel, pipeline, rail, and trucks, carried more freight by value in June of 2014 than in June of 2013, according to the Transborder Freight data that was released by the Department of Transportation's Bureau of Transportation Statistics. And of the $9.5 billion, or a 10.2% increase in U.S. NAFTA freight from June of 2013, truck freight contributed the most, $4.4 billion, followed by pipeline at $2.1 billion. The trucking increase predominantly due to an increase in the value of U.S.-Mexico truck freight, which was up $2.9 billion, or 64.8% of the total trucking increase. That's the news. And again, it's 8888 Road Dog. Attorney Peyton Inge with me. Sir, where can they find you on the web? You're up for a lot of great stuff. Where can they reach out?
Well, they can find me here at the firm's website, ChambleeRyan.com. That's CHAMBLEE Ryan, RYAN.com.
All right, outstanding. Thanks for breaking these stories down for the drivers out there. And you have a CDL, correct? And you have your own truck, which is really cool.
Yeah, I do have my own truck. I actually gave up the CDL part a few years ago, but I have the Class A private license that they let you have here in Texas to drive it.
Oh, very cool. And you take that to shows and all that?
I do take it to shows and use it for marketing and take it to races sometimes, things like that.
Oh, very cool. Outstanding. Yeah. Once you get behind that wheel, it's very infectious. And thanks for spending a few minutes talking with the drivers out there. I do want to go to Ray in Oklahoma. He's got a comment about the FedEx story before we move on to Susan Collins' story. Ray, welcome to the program. What's your thoughts, man?
How you doing? I don't know if it was FedEx or UPS, but somebody went through the same thing about 3 years ago. And I was leased to a carrier. I watched it really close. And when the judge came down to his final decision, he said, "No, just like where I was working, I hauled hazardous waste. I was under their authority, had to take training classes, didn't have to wear a uniform, although I did." And the judge finally just said, independent contractors have the right to refuse a load. Employee drivers do not. And therefore, he kept them as independent contractors at the time.
Okay. All right. So this is This has happened before, and you were with them at the time. Did that change your outlook?
I was with a company hauling hazardous material,
Okay.
but I think it was FedEx went through this same thing 3 years ago.
Okay. All right, so there is some
And that was the
historical
big
precedent.
decision. If you can say, I don't want to go there, give me something else, then that was the decision that the judge used.
Yeah. Okay. All right. I appreciate it, Ray. Thanks. And let me ask you this, Peyton. Do you think this is going to mean a patchwork of court decisions that will come out of all of this, ultimately getting appealed to, like the Ninth Circuit Court? And could this, in your estimation, eventually wind up in the Supreme Court?
I think it ultimately will have to. Whether or not it happens 5 years from now or 40 is hard to say.
Yeah.
But you can't have you can't have a patchwork of decisions affecting drivers and affecting companies on such a large scale without beginning to affect commerce and costs. And I think for that reason you'll eventually see a congressional attempt to address it again, to make it clear to the states that, look, this is in fact an interstate issue that the federal government has authority over and can in fact regulate. It would not surprise me at all, and given that we rely so heavily on trucks for every item we use in our day-to-day life,
Yep.
It would merit that type of attention.
Yeah, absolutely. All right, Ray, thank you, man, for the call, and that's going to free up a line at 8888 Road Dog. Peyton, before I let you go, I wanted to have you address the story involving Susan Collins. Everybody knows Congress has been out on their summer break. They're getting ready to come back from the lake or, wherever they have been for the last month, and they're going to pick this all up again going forward here. And the Susan Collins amendment is going to be first and foremost on the minds of a lot of lawmakers. In essence, Ms. Collins' amendment is proposing to put a maneuver in place here that would put a pause on several regulations related to the hours of service a truck driver can log before taking a mandatory break. It's going to require the Department of Transportation to study all of the impacts of those regulations before advancing any new rules, and something one might assume would be mandatory in this particular case. From your observation, what are you hearing from drivers out there? Do we need to put a pause on this whole thing with the 34-hour restart, maybe go back to the original rules we had in place July 2013 to give the Department of Transportation a chance to study all of this again?
Yeah, the short answer is yes. I think that we do need to put a pause on the new regulations. I haven't seen anything that suggests the new regulations have affected traffic safety at all. And I think that looking at the different elements of the new rule, you have to be a rocket scientist to figure out how to apply it to you as the driver.
Yep.
It just doesn't make any sense, and I understand the concept, but typically concepts are not come up with the people that are actually doing it day to day, and come up with in a box, and they're developed by bureaucrats. And it's not a bad thing. They're trying to make things safer. It's just they don't really have any real-world experience doing what they're preaching. So looking at her amendment, I think it's a great idea. I haven't been able to find anything that identifies exactly what that amendment is. There's a lot of different stuff out there that says one thing versus another. I do think one of the things that she is trying to get rid of is that requirement that you have to have sleep between 1 and 5, 2 consecutive days a week, which certainly seems like a good idea to me.
And from that standpoint, though, I mean, a lot of drivers have called in and said, with that overnight break that we've got to take, it's cut down on productivity, it's created a problem, putting us back out on the road in very unsafe driving times like morning drive, for example, some of the heaviest travel times during the day. Trucking companies have reported this whole hours of service bailiwick has cut down on their production. Some companies losing 10, 20% of production levels. I mean, the ATA's come out against all of this. White has come out against all of this. There seems to be a universal cry here for some kind of relief. And you've been in the court system for many years, and you've seen how all of this progresses. What does your gut feeling tell you? Is this going to be a long, tortuous battle for the trucking industry to try to implement these changes?
To implement the changes, yeah, I think it'll take some amount of time to get used to, and then time for the costs associated with those changes to fully develop. In terms of looking at the requirements of the current rules, it just, to me, the federal government should never be trying to tell a truck driver when he should or should not be on the road.
Yeah, absolutely.
And I think that is ultimately what they're trying to do. Obviously, it's couched in terms of this is in the best interest of society, but this country wasn't founded on the concept of someone telling you when you can or can't be riding your horse, or in this case, driving your truck down a public road. And I think that eventually it's going to have to be rolled back. I didn't see any rational basis for it, and I think this proposed amendment goes a decent way down the road in terms of trying to make sure the Department of Transportation properly thinks through each and every of the regulations that it imposes on commercial truck traffic.
Yeah, okay. I got to break one more time. Drivers, you got Peyton Inge with us on the radio. If you want to talk to him, it's 88 Road Dog. Last commercial break. And we'll get to that coming up right after this traffic noise right here on the Sirius XM Road Dog Trucking Channel.
The news and issues affecting drivers. Now, back to Sirius XM Road Dog Trucking News.
You know, ladies and gentlemen, I've had attorney Peyton Inge on the program with me before. And Peyton, again, I appreciate you spending a few minutes with the drivers out there. And drivers, he is in the trenches. In other words, boots on the ground, defending trucking companies in courts. He is an advocate for you guys out there in the trucking industry. And Peyton, I would like to formally nominate you as the next head of the Federal Motor Carrier Safety Administration. Are you willing to take that job?
Of course.
Are you really? Wow, why would you do that? Man, Ann Farrow just left, and I'm sure, she's not looking behind here. She's going off to a brand new job. And, this has been in the works since April. That's when she started looking around. I do know that. Some folks are taking credit for maybe running her out of the industry, but, that's not the case. I mean, she was looking for quite a while. The job of FMCSA administrators, I think, a thankless job. You cannot please everybody. The administrator's job is getting orders from Washington. That's how those orders come down the pike out there. What criteria, what do you think? I mean, you've been in the trenches with the trucking industry, fighting a good fight, so to speak. What kind of criteria does somebody need to meet in order to be an FMCSA administrator? Do they need to have driving experience first and foremost, having worked in the industry, in other words?
I think they have to have real-world experience. If not driving, they need to have certainly been involved in the management side of the company, or maybe in the safety side of the company, to be able to fully appreciate and understand the logistics and the concerns of that industry.
And from that standpoint, I mean, that means understanding the hours of service, the complexities of logging, the ELDs, the delays at the shippers, at the consignees. In other words, everything, top to bottom, left to right. Correct?
Correct. Absolutely correct.
Yeah. And I think that's going to go a long way. I mean, I know there is an interim director that has been named to take Ms. Farrow's place, but I don't think a permanent appointment is going to be made for a while. I mean, we've got the elections coming up in November, and then the presidential election is just 2 years after that. So this may be kind of a temporary measure, so to speak. I mean, the clock for that new person, whoever it is going to be, is already going to be ticking, because the person that serves as the head of the FMCSA serves at the discretion of the Senate and also the president. So again, maybe just a short-term phenomenon for that person that's going to be coming in. Do you